Mr. Washington, I first met you when you appeared on television speaking about the Jena 6. If I recall, what you said at that time was that it had been determined that no hate crime had been committed. Is that true? Is that what you said on television?
That there has no hate crime committed at which stage? The December the 4th incident, or at some other stage of the timeline?
Do you remember when you were on television making the statement?
I do.
What were you referring to?
It depends on what the question was. If she was talking about the December the 4th incident, I've been, I think, fairly clear that I did not believe that that was a hate crime because of the statements that I've read and the information contained in those statements. With respect to the August 31st hanging of the nooses, the September the 1st incident, I think we've been fairly clear that that had all the elements of a hate crime. What we're missing there, of course, if we were to proceed forward, would be evidence and an adult to move forward with. It's not that at the end of the day that it's not, whether or not it's a hate crime on the noose hangings.
Well, that's really what I'm referring to, and that's what I thought I saw you speaking to on television, where you had determined that it was not a hate crime.
No, there were a number, no ma'am.
That's not what you said on TV?
No ma'am.
All right, that's good, that's fine. Does the state of Louisiana allow for the trying of juveniles as adults for attempted murder?
It is my understanding, and again, I'm not a lawyer.
Well, you should know by now.
I'm not a lawyer who's ever practiced in Louisiana, so let me qualify my answer.
That's okay. You should know by now. What is it?
It's my understanding, based on Louisiana law, that a juvenile can be transferred into the adult criminal justice system with a charge such as attempted murder.
With the permission of the chair of the committee, I'd like to have entered into the record the decision of the State of Louisiana Court of Appeal, Third Circuit, on September 14th, 2007, where it concluded that,
without objection, so ordered,
that Michael Bell should not have been charged with aggravated battery as an adult and reverse that conviction. So the record is clear. The Louisiana Court of Appeals for the Third Circuit made that determination, and it was clear that he was overcharged, that the lawyer who represented him didn't try to prevent that from happening at his original charge, that the court didn't grant a dismissal of the charges as the lawyers had requested, and only when it went to the appeals court was it finally rectified. So the error occurred from the time Michael Bell was charged and wasn't corrected until, gosh, a year after the charges. And that the record on it is absolutely clear, and I'd hope that we can submit the rest of the material as well.
I don't know if I can get through the questioning because as a parent, I'm on the verge of tears. Michael Bell is now in jail. Marcus Dixon is now in jail. My good friend Congressman Scott has laid the legal precedent, and I am not going to review that. Let me thank the NAACP for burying the N-word, nigger. But Reverend Moran said that the children were called niggers. Let me go forward to U.S. Attorney Washington. September 2006, 3 nooses were found hanging. The principal said, let's expel them. The students were suspended. Then in the fall, we had a series of fights between black and white students. In late November, arsonists set fire to the school's building. A white student beats up a black student who shows up in an all-white party. And my understanding is that a shotgun was pulled by a white man on 3 black students at a convenience store. Let me ask the chairman to put into the record, U.S. Attorney, nooses beating at Jena High, not related. Nooses incidents evoke segregation. You stated on the record that nooses equal hate crimes. I'm asking you now, first of all, to go back to Jena, Louisiana, in the symbolic position that you hold, one, because you merited appointment, but you are the first black Western District U.S. Attorney. And I'm asking you to go back, and I'm asking you to find a way to release Michael Bell and the Jena 6. My question that goes down the road. I want to know why in the course of meetings of local district attorneys, why you didn't engage with Mr. Reed Walters, who may be subject to prosecutorial abuse, and confer with him and say, Mr. Walters, this is not the way to handle this case. I can see disparate treatment by white students being suspended back in school and by Mr. Bell being still in jail on an offense that he served 10 months for, 10 months, and therefore the juvenile judge could have said time served and he could have been released. I want you to tell me why you didn't engage with the DA, and I want you to tell me what you're going to do now. Reverend, I'd like you to tell me how they treated us when they came there, and Dr. Ogletree, please tell me what federal action legally and legislatively that we can have. Mr. Washington, tell me why you did not intervene, not by way of the legal system, but the consultation that the U.S. attorneys have with the local district attorneys. Why didn't you intervene? This broken lives could have been prevented if you had taken the symbolic responsibility that you have, being the first African American appointed to the Western District. I don't know what else to say. I am outraged, and that's why my voice is going up like this, literally outraged.
Mr. Washington, you used your discretionary latitude to decline the juvenile proceedings for the noose hangers. Isn't that true?
Actually, what our process is
I need a yes or no, sir.
well, I'm trying to answer your question the best.
No, I'm not going to let you waste my time. I need you to answer my question.
My office works with, or actually the Civil Rights Division.
Sir, I got 5 minutes. I'm not going to tolerate you wasting my time. I need you to answer the question. You used your discretionary latitude to decline the charges on the noose hangers. Isn't that a yes?
No.
Okay, well, we got two learned counsel that says that's not true. Now, in the course of this, my time on this committee, we have dealt with 8 U.S. attorneys who were fired because they did not slavishly obey the dictates of the Bush Justice Department. And we had some people who got promoted, benefits accrued to them because they did do what the Justice Department wanted them to do under Gonzales and Bush. You still have a job, don't you?
Yes, sir.
And I almost fell off my chair when you invoked the name of Martin Luther King to say that you were somehow the culmination of his work. Sir, I would expect you to quit in protest based on your inability to use your discretionary latitude to charge these noose hangers. That's what I would expect of somebody who was truly in fidelity with that great legacy of Martin Luther King. But I just wanted to just go back to this 8 U.S. attorneys things, because this has taken up a lot of time here. And one of the things that always concerned me is not just the 8 who were fired because they wouldn't bring fake voting rights cases, but the people who stayed and kept their jobs. These people are the ones who I'm truly concerned about. And I guess, you know, one of the things that I would like to know is, Mr. Washington, have you prosecuted other juveniles? In your tenure as U.S. Attorney, have you prosecuted other juveniles?
No.
You've never treated, because let me tell you, I've defended juveniles in federal court.
Yeah, well, I don't.
No, let me tell you, sir, I spent 16 years as a criminal defense attorney, and I've tried over 100 cases to a jury, and I've defended juveniles in federal court. So you can't tell me that the federal government doesn't prosecute. You prosecute them for having 5 grams of crack cocaine.
Well,
you throw them in. You put them in jail for that. We have incarcerated generations over your drug war, and I say it's yours because you will not step away from an unfair system. And but what about the selective justice? You're telling me you have never prosecuted a juvenile. We're going to find out.
No,
is that your statement is that your statement before Congress?
In my district, and you're asking me, I guess, about the Department of Justice, and I cannot speak to whether or when or how we prosecuted juveniles.
Right. Well, let me just say this, Mr. Washington. You've been on record saying that you believe that the noose hangers didn't commit a crime, and now you're saying today that they did. I'm glad to see that. I don't want to give you credit for that. Have you changed your mind? Does that explain your change in testimony?
I don't believe so, sir.
Have you come to see the light? Is that why you're saying that it's a crime today?
I don't think I've changed my testimony.
Well, you changed your statement. Do you agree with that?
I don't think so.
If you claim to be a beneficiary of the work of Martin Luther King, you've got to stand on that. You can't just, it's not a matter of career advancement. Martin Luther King did not do his work so you could get a Lexus and a nice house. It's not just a matter of your own career advancement and buying consumer items. It is fidelity to a set of ideas.